Well, I see no more feedback in the chat. I see our friends who have joined us throughout this forum. I see Tat-Adi and the moderator. Most importantly, I can see the moderator and take my break. Nataliia Mazaraki, it is my pleasure to pass on to you. I am sure that in your able hands, speakers will feel comfortable and cozy. This is indeed important. As mediators, we understand this very well. So Nataliia is the team member of the Ukrainian Academy of Mediation. We are proud of our team members. It's a reliable shoulder to rely on. Nataliia is PhD in law. She's also professor of State University of Commerce. And also, Nataliia, her first PhD on mediation lay the foundation, theoretical foundation for developing mediation in Ukraine. So the floor is yours. Dear Louise, dear participants, thank you for presenting me and welcome. It is my honor to moderate this most interesting panel of this forum. The history of this forum shows that the program always looks into the future of mediation development in Ukraine. And each new forum improves the understanding of what is coming up next. And this forum is no exception. And the panel on the quality of mediation services is something that mediation community is thinking about, the bar, the judiciary, legal aid. And so by inviting distinguished speakers, both foreign and national, we will be able to absorb their experience, both personal and institutional, and understand better what the mediation community is doing to ensure the quality of services. We'll hear from the academia. As a moderator, I did take a sneak preview of the speaker's presentation, and I can tell you that over the next 2 hours, we will see a much better understanding of what the mediation quality is about, what is a well-mediated case, and what is poorly mediated case. Who should ensure the quality of mediation? What criteria should we rely on when measuring mediation services and its quality? And do these criteria change depending on the type of mediation? According to the agenda, we have just over 2 hours. And so that means each moderator has 20 minutes. But I would also like to leave some time at the end of the panel for discussion with speakers. So please make sure you prepare your questions ahead of time. And 3 minutes before your time is up, I will remind the speakers and give them a tip, a reminder.
Пан Константин-Аді Гаврила.
Constantin-Adi Gavrila will be the first speaker. I read about him because I read about every speaker today a little bit, but he not only has PhD, he has unique experience and great institutional particular experience in mediation, as well as personal experience, work experience as mediator, or in fact, over 20 years. He is ID Center Romania director and head of IMI Independent Commission. He mediated hundreds of cases, multilateral, company versus community, large banks. He designed training programs for thousands of mediators from over 30 countries of the world and conducted trainings for mediators all over the world. He designs policies, techniques, and was awarded for leadership qualities. Myself, as a researcher in Mediator, of course, know him first and foremost as an author of many publications. Okay, dear Mr. Gavrila, I hope I've introduced you well. Dear participants, it is my pleasure to pass on to Constantin-Adi Gavrila.
Thank you. Thank you very much, Miss Moderator, Nataliia, if I can call you Nataliia. Thank you, and feel free to call me Adi. It's easier, it's shorter, actually. Let me do the math correctly. Do I have 15 or 20 minutes for the presentation, just to be clear?
20 хвилин.
You have 20.
Okay, thank you so much. I'll try to stay within let's say 15 to 20 minutes so that we have time to discuss, because me personally, I prefer discussions and engaging participants directly. And I'm looking at the screen, I see 244 participants connected. Wow, this is fantastic. Hello, everyone. A good day to you all, wherever you are. And I know there are so many friends and colleagues connected here from so many places all over the world. So it's a really an honor to be here. And I'd like to start by thanking for the invitation to the Ukrainian Academy of Mediation in general, and in particular to Luisa Romanadze and the IMI Executive Director, Ivana Nincic, for recommendation. It's an honor to join this panel. Tat, my good dear friend and colleague, and all the other speakers, of course, and to connect with you all after being connected last year, when I had the privilege to discuss more around policy-related topics. Unfortunately, since last year, the times for Ukraine are still challenging. And my thoughts and heartfelt sympathies are with you all, with the Ukrainian people. And I was listening to you, Luisa, talking about hours and hours without electricity and all of that. Just, thinking about your resilience and dedication to really discuss all these things, mediation in such a context, is really, truly inspiring. So kudos to all. Now, I'd like to share my screen to talk to a deck of slides. I hope you will all be able to see it. Okay. Okay, thank you. Thank you very much for the non-verbal confirmations. So I'm working with the ADR Center team, bringing regards from Leonardo D'Urso, ADR Center CEO, with whom I have been working in many countries, trying to promote mediation and to support governments and institutions implement public and corporate mediation policies. And obviously, the quality is an important topic. The question is, however, and perhaps being the first to talk as part of this panel, is let's take the bird's eye view. At least this is what I tried, okay? So whether I achieved or not, you will be the judges of that. But I wanted to take the bird's eye view and to really present ADR Center's research in terms of what are the building blocks, basically, when we talk about quality, because we have a tendency of associating quality only with mediators, and I don't think that's the case. I think quality is about so much more than mediators. And also, as a good friend of mine said, a good quality mediation, you know it when you see it. It's more difficult to talk about it and to really describe it, really. So it's really, you have to see it to actually recognize it, right? So the first thing I will say is that at ADR Center, we're seeing quality as part of the supply side of mediation, ecosystems. And when we're talking about ecosystems, we're looking at least at three buckets: demand, supply, and environment or setting. So today, I'd like to just take a few minutes to present these 5 points. The regulation of the procedure, whatever is policy that should inform the process of mediation, obviously with impact on quality. Sometimes they're doing much harm than helping. Sometimes they're helpful because they achieve minimum standards, but it's not always the case. I can give you examples of situations where mediators are saying, we hate this policy. We don't want to be limited like this or like that. So that's the first element. The second one refers to mediators, yes. The third one refers to mediation providers. So we're looking at providers from a different perspective than mediators themselves, although we do know that mediators could be like solo providers of services. But nevertheless, there is a different discussion to be that we can have in terms of looking at groups of mediators offering mediation as part of a provider that has perhaps mediation rules adopted to be governing all the mediations that are being offered by the mediators working within that space. And then, of course, we have mediation trainers and mediation training entities who are, again, making a significant impact on quality. Okay, so for the purposes of this presentation, I did include information about the first dimension, let's call it mediation demand, and the third one, let's call it mediation setting, which is like the environment that the demand and supply is actually working and is creating a reality, a practice. Of course, only with this setting, only with this environment, you cannot create a reality, but the reality needs actually also an enabling setting, let me call it like that. So I'm going to really skim through the first and the third dimensions or tracks of this so-called, by the way, 3-track methodology or 3TM. And the first one refers to the dispute types that could be subject to mediation in any jurisdiction. The second one refers to whether there are any pre-litigation requirements. At least in Italy, this element alone determines 85% of the mediation demand. And this is data, not opinions, after 10, 15 years of piloting. The third one refers to the court referral dimension, the cases that are being driven towards demand for services because of the judge referral and the court-connected programs. The fourth and the fifth refer to voluntary recourse to mediation and the contract clauses. So this is like the first one, the first dimension, which we call at ADR Center mediation demand, and that we discussed last year. Let's look at it in more detail at the second one, which is the topic for conversation today. First of all, there are five topics basically within this bucket category. The first one refers to the regulation of the procedure. Let's not only think about commercial mediator in whatever country, looking at the mediation legislation, whatever the mediation legislation provides for the mediation process. It could be a workplace mediator working for a company which has corporate mediation policies. The way that internal mediators working for that company are helping colleagues, it's the same. It's the regulation, it's the way that that procedure is regulated within that company. Okay, so we're not only thinking about the legal framework here. Whatever it is, we believe that there has to be clarity and there has to be predictability in the way that mediation is governed according to such regulation. And at the end of the day, as long as the parties are free to choose their own process and the good international practices are applied, such as self-determination, process confidentiality, these kind of things, the regulation could actually increase quality, okay? It may refer to the relation to the way that cases are handled in the relation with the courts. It may refer to the safeguarding confidentiality, as I mentioned, statute of limitation, just to ensure that if no one is mediating to try to kind of delay the resolution of a case, which can happen actually. And then we would be ethically challenged what we would do as a mediator if that's the case, right? And obviously the enforcement of settlement agreements. So these are all things that are not, they don't depend on us as mediators. They're like given and they're environmental. And this is an important element that influences quality. And we have to be aware of all these things. That's what this element is all about. And just to give you two examples, you will see in the presentation, there are some countries like Italy or Azerbaijan, where there actually is like a predetermined process in the way that cases are handled, predetermined timeframes. So you have to go back in 30 days or in 60 days or in 90 days, and this invitation has to be sent according to this, template and process, and all these things are kind of written and they have to be followed. Whether that's a good thing or not, it's for another day. What I'm saying is that we have to be aware of the environment that we're operating within. Quality is not only about what we can influence, it's also the environment that is kind of telling us that we have to follow some procedures. This is the process in Azerbaijan. Oh, by the way, these are all these two examples related to this first element refer to the way cases are handled pre-litigation, because there is a requirement that the mediation would be considered, at least by the parties, to attend the first meeting for some types of cases. And I see Ms. Albena Penova in Bulgaria, and I know this is an important topic nowadays in Bulgaria as well, and it is influencing quality for sure. Okay, let me go to the second bucket. Mediators. Very important, obviously, and this is probably about quality of mediation, focusing on mediators' continuous professional development, right? All these accreditation criteria, the basic mediation training that mediators should undertake, competency frameworks, being able to really clearly crystallize the competency areas, the competencies and the skills that mediators should have to be licensed for practice. I'm talking driver's license, right? So it's not experience level that we're talking about. It's just, what do you need to achieve in terms of knowledge, skill, and attitudes at the end of training to be able to mediate according to policies? Because sometimes in some countries, there are no policies, there are no accreditation, there is nothing. And you just, mediate if you want. You don't even have to go through training. There are other countries where professional associations are setting those accreditation criteria. Other countries are embedded in the law. So it really depends. And that corporation that I was talking about earlier, they may define as well criteria for internal mediators to be able to operate. So this is what this bucket refers to. What does it mean in terms of criteria to be able to provide the service? What is the minimum requirement for training, continuous training, initial training and continuous training? And then whether there should be some dispute matter expertise. I wanted to jump in when Jeremy was speaking because I had different thoughts of mine as well. So that's that will be an ever-living topic, subject matter versus industry expertise. And then, of course, accountability, insurance, professional insurance. How do we ensure users that we are accountable for our services and they have a recourse for remedy if they have? I should move quickly, probably, because I said I will finish in 15, but I think I'll have to take the full 20 minutes. Nataliia, sorry. Just to give you an example here, this is something we've developed at ADR Center. It's called the 5x5 matrix. It is breaking the mediation process in 5 stages: set the stage, open the process, listen and understand, validate options, and enable resolution. Kind of good practices where you have the interest and the needs exploration in the L stage. But for every single stage, we differentiate targets, goals to achieve during each stage by activities, what you could do to achieve those goals as in activities. And then strategies, different ways we could implement those activities so that we achieve those goals. And then what are the keys, the tools, the tangible tools that we could use to implement those strategies? And finally, what are our personal skills and to communicate and negotiate? So some of them are relevant, more relevant for some of these stages, other as well. So altogether, this is a methodology called solved tasks. And Tat was kind enough to provide feedback when we were developing this. This is just an example of how you could look at quality in terms of making things very clear for the mediators that you prepare and you work with. The third element, mediation organizations. I don't want to spend too much time here. Basically, it refers to mediation providers. It's an important discussion because sometimes the society is not taking us seriously because users, stakeholders, the general public, they see us like, sometimes one mediator in one little room providing the service is not like an institution. They don't trust us because we're just We don't appear to have the capacity and the experience and so on and so forth. So being able to institutionalize the service and to present ourselves as providers, not only mediators, could probably be a good discussion about quality. And then, of course, you see here that at the provider level, you have some governance, some accreditation schemes. You need some infrastructure, not only real estate, but also virtual. And then some conflict of interest elements, because we see sometimes different industries creating their own internal mediation providers. We're only mediating our own cases coming from our own industry, where the actual interest is that they don't want to take their problems outside the industry. Which makes sense. Actually, it makes sense to me because they just want to keep things contained. Question is, if those cases don't settle, perhaps other mediators can look at those as well. So there is an example, the European Code of Conduct for mediation providers. No time to discuss this right now. Quickly, fourth bucket, mediation trainers. And who can be a trainer in a jurisdiction? How do we train the new trainers? How they develop? I'll give you an example from Romania. I was the vice president of the first Romanian Mediation Council back in 2006, many years ago. I didn't want to have anything to do with the Mediation Council from Romania, which is like the regulatory body established by the law. Guess what happened after? Every mediator wanted to be a member of the Mediation Council, so they create their own mediation training providers. They accredit themselves as mediators, and then they can offer mediation training for revenue purposes. That's the problem. This is what we're discussing, and this is what's affecting the quality. I know I'm past my time, Nataliia, so let me just conclude.
Great,
if
thanks.
This is what I know, I apologize. So yeah, there is another example here, and the training entities was the final, the fifth bucket, basically, trainers and training entities. And the final example is the IMI criteria for certified mediation training programs. Okay, you'll see all the presentation when it will be shared with all of you. Let me just conclude by saying this. Quality is an important topic, but without practice, quality will not exist. We can train all the time, but until we get to actually practice, it is difficult to develop intuition and flexibility. So my suggestion to you all, take every opportunity you can to actually practice, because I don't want to get into an aircraft and the conductor to say, welcome everyone, I've been training for 20 years and this is my first flight. I don't want to be there. Same goes for mediators. Thank you, Nataliia. Over to you.
Шановний Аді, я дуже вдячна за вашу
Dear Adi, thank you so much for this outstanding presentation.
примусила
You
замислитися
know, it
над
forced me
новими
to think
гранями
about the
цієї
new
проблематики.
facets
Дійсно,
of this
якщо не
topic.
практикувати
If not practicing
медіацію, то якість того ми
mediation, then
збираємося на
the quality of
суді,
what are we
збираємося,
supposed to measure?
вимірювати.
There is nothing
І
to
саме
measure them.
тому я і
That is
казала
why
про те,
I
що
alluded to this fact that
проблематика якості
the
медіації
issue
є
of
на часі в
mediation
Україні, де
quality
ми
is so
бачимо
timely in Ukraine.
розгортання
And we can see that
нарешті
more and
практики
more practice is
медіації.
getting
Дуже
deployed,
дякую за вашу
and we
доповідь і
have
прошу
much more to
залишатися
measure.
до
So please stay with us.
фінальної
Thank you very much for your
дискусії.
presentation and
Зараз
wait
я
until the end of
з
the final
радістю
discussion.
передаю
It is my
слово
pleasure
нашому
now to
наступному
hand the floor
спікеру,
over to our next
пану
speaker,
Тат Ліму,
Mr. Tat
який
Lim,
має
who
настільки
has
величезний та
huge
багатогранний досвід,
and
що,
multifaceted
мабуть, він забере дуже
experience.
багато часу
And I'm probably
із
taking so
його
much time
презентації, якщо буде
from his
говорити
presentation
про
if
це.
I introduce
Але
every
лише
detail about
деякі
him. But just some of the facts, please.
Пан Тат має за своїми плечима понад 300
Tat has
медіацій,
over
адвокатський
300
досвід
mediations,
більш
and
ніж
his
500
experience
медіаційних справах.
covers
І
more
ви
than
це
500
побачите в
mediation
його
cases. And you're
презентації.
going to see this from his
Він
presentation.
працював медіатором і
He has
працює
worked as a
медіатором
mediator, and he
у
continues to
найбільших
in the
міжнародних
largest
медіаційних
international
центрах,
mediation
як і в
cases and
Сінгапурі,
centers in
В'єтнамі,
Singapore,
ICC,
Vietnam, ICC,
та в інших.
and many other settings.
Його професійний рівень,
His
його
professional
впливовість
background
завжди
and his
визначалася
influence
різними
have always been
преміями,
rewarded by so many different prizes. In 2022, for instance, this was a WWL Global Elite Thought Leader, which tells a lot about Mr. Tat's professional expertise. He's been doing trainings and mediation sessions at universities. He sometimes is an arbiter in the mediation contests and competitions. He is part of the IMI board. And what's most important and remarkable for me is, of course, his publications on mediation topic. Mr. Lim, the floor is now yours, and we can't wait for your presentation because I saw the slides already and I can't wait until you present them. So it's so wonderful to hear your experience. Please, the floor is yours. Over to you, 20 minutes. 3 minutes before I'm going to give you a warning. Time is almost up. Please go ahead.
Thank you, Nataliia. Thank you all. Need to say thank you also to Lisa and to Ivana for this opportunity. I must start by echoing the words of my good friend and colleague Adi, that it is so inspirational to be participating in this forum, in this workshop, in the midst of what you are going through. Again, my heart and thoughts goes out to all of you who are living there, but you know, I think the inspiration comes to us from you rather than the other way around. I must qualify what Nataliia had mentioned. Of course, all those kind and very generous words that she spoke about, of course, they're all written by me. So it is how, of course, mediators publish our experience. But I hope that maybe today, some of the things I say may resonate with some of you who have been in practice, and if you have not been in practice but have been involved in disputes, that some of the words and my description of my experiences may also resonate to you and give you some food for thought. I mean, that's all I hope to do. I want to move towards more the issue of experiential and focus on what perhaps users would be looking for in terms of quality, and how I want to allow you to think alongside me is to ask ourselves questions that I think users would often ask themselves rather than you know, practitioners like some of us who are either lawyers or mediators or non-lawyer mediators who may look at it from a distance or who may be approaching this from a very professional point of view, right? So focusing on the users, focusing on people who are in disputes, who may have experiences by using mediation, and asking that question about what does quality mean to a user of mediation. So to help me do that, I am going to just use my slides to share, and I see that Nataliia is asking, do I remember my first client in mediation? I can remember the first group of clients. The very first one probably escapes me because probably I was too young and too nervous then. Let me share a little bit about the user's perspective in terms of quality from maybe three perspectives. The most important I think I would want to focus on is an anecdotal point of view, meaning that it's not a research point of view, it's what I feel a person experiences. I speak about my experience as a disputant, as a party in mediation, using the mediation process. I speak then about myself as a lawyer, helping a client, representing client or clients in the mediation process. And if we have time, we have a look at the Singapore International Dispute Resolution Academy survey. The last survey was done 2 years ago, where it polled users, clients, and lawyers on what they consider important in mediation institutions, and how satisfied they were with all of those factors that they say they consider important. But the information is out there, and if you do want to see the survey, it's available on the internet as well. So If we do get to that point, there's not enough time, I encourage you to look up the data. But I start from the point of view that as a user of mediation, I think your perspective of the dispute, of the process, I think may vary very differently from the professional's point of view. And if we start from that point of view, I think it would be useful for us to think about whether there is a disconnect sometimes between the professionals who are either administering the mediation, meaning the mediator's point of view when the mediator is facilitating the mediation process. If it's a process involving lawyers, the lawyers who are helping the parties to provide representation in the process, their views, are they aligned with the concerns, the views, the interests of the disputant, the parties who are involved in the case, who are there to try and resolve the case using the process of mediation? I reach back into myself and try to recall what it was like for myself in this case when, well, closer to now, almost, I suppose this would be 2024, maybe 15 years ago, I found myself unusually involved in the dispute, because you think that if you are a lawyer in practice, you know that the last thing that would happen to you is that you're actually involved in the dispute yourself. But I became part of, at that point in time, a member of a committee who was in an estate, managing an estate on a voluntary basis, and I got involved in legal proceedings with one of the owners. And if you see the string of description of cases in the box below, you will see that actually it's not just one case. Out of this dispute sprung multiple cases, all revolving around the owner, as well as myself and my committee members. And so it was actually the first time, despite having practiced as a lawyer for many years and being involved in mediation as a mediation lawyer for many, many years, and also having at that point in time mediated as a mediator for over 50 cases. But first time in 2013 that I was a party to a mediation. And all this happening in the backdrop of a dispute that had become very contentious, where there were a lot of language spoken in meetings in almost semi-public environment that made you feel very hurt, that made you, you know, feel very concerned every time you see an email that comes to you relating to the subject matter, where your professional career was under threat because there were complaints, in this case, to the Law Society, and where it also placed stress on, you know, myself, in this case, individually, because we had lawyers who represented us, and the legal fees were, as with lawyers, legal fees are never cheap. And in this particular case, by the time we went into mediation, it had cost each of us close to $100,000 Sing, which is, I don't think by any measure, a small sum of money. So that's the backdrop. For some reason, I had expected the mediation to be, you know, of the kind that I've been so used to in practice, you know, going in, you know, thinking with a clear mind, engaging in all the concepts that all of us have been discussing, you know, active listening, thinking about options to satisfy your interests, you know, measuring that against criteria, objective criteria, and finding whether or not the best options weigh against your BATNA, your alternative, would come out the best. I found that, you know, as a disputant, as a party to the mediation, none of those concepts appeared in my mind. In fact, I would go as far as to say that throughout the entire mediation, I felt like the process was very disconnected with what I wanted to accomplish. Did I participate in active listening? It was very difficult because everything that was spoken by the other side just felt like it's something I didn't want to listen, felt dishonest, felt fake, right? And the whole range of emotions that were stressful came upon me, made it very difficult for me to sit there and participate in a way that we always, either as trainers or as professionals, encourage our clients to engage in the mediation process. So, you know, in the process itself, did I feel like sharing my personal information? thoughts that were dear to me with the other party? No, I didn't. I didn't want to share anything that was personal to me. Did I feel like extending an olive branch to the other side, thinking about win-win solutions? No, I did not want to do that. Did I feel like, given the cost and the time involved in litigating this, that it would be in my best interest to settle the dispute through mediation? Well, my head tells me yes, because I'm conditioned by training, but my heart says no. I want to punish the other person. My heart says that, I would like a process where I'm vindicated by a higher up authority, and at the end, justice, my concept of justice would be I win in a forum where it's very public, and that vindication comes at the cost paid by the other side. Reflecting, that was a very significant discovery for me. Significant because it ran counterintuitive to everything that until that point in time I've been teaching and training people in mediation, and also very counterintuitive to the kind of thought process I engaged myself in as a mediation lawyer and as a party representative. Moving ahead with this story, the case didn't settle at mediation, and the thing is, when it didn't settle, instead of feeling remorseful that we didn't achieve a settlement, in fact, it motivated my co-disputants and I to want to go even further. We were prepared to go to trial no matter the cost. Reflecting the mediation that we had, and this mediation was conducted by a very reputable, very experienced mediator, someone who was very dear to me, someone I trusted. I must say that it felt very unexceptional. I used the word almost like a letdown. It felt like the amount that we paid in the mediation process didn't commensurate with the gains that we accomplished. And I must say, overall, my experience in the mediation as a party, as a disputant, wasn't very happy. And so I don't know how many of you feel that same experience. If you've ever been in a dispute, either with people you love, or in relationships that didn't work out, or with business partners, or even we think about what's happening now in the place that you live. Why there's sometimes a process which we say is the best way to resolve disputes not deliver this sense of satisfaction. Has it got to do with quality of mediation services? And that's one of the questions I invite you to ask yourself and walk alongside me. I asked myself this question why many times. And I suppose you could say the years that followed then, one of the key thoughts that keep recurring in my mind is perhaps focusing on what Christopher Moore an American mediator, has sometimes called, perhaps we can look at satisfaction from the point of view of the triangle of satisfaction, right? And we know the three parts of the triangle is that, when you think a process like mediation, satisfaction could be psychological in nature, meaning that you go into a mediation, you feel like your needs have been satisfied even if you don't settle, right? And of course, the second part of this triangle is that if you go into mediation and you do settle, well, that forms a great part of the process. But even if you don't settle and you do get your psychological needs satisfied and you feel that the process has been fair to you, the mediator has been fair to you, that would be the third part of that triangle. So the triangle of satisfaction gave me food for thought, and I felt intuitively that it made a lot of sense to me as a person, right? No longer thinking about abstract notions of theories, but I felt that it does make sense if I were to break apart the lessons that I've learned as a disputant in terms of this quality of the mediation services I receive as a disputant. Why was I dissatisfied? And now I break this up and I think about the procedural needs. My procedural needs, right? Was it fair? It wasn't unfair, but again, mediators have different styles, and this particular mediator liked an opening where he had a particular icebreaker where he asked all of us to talk about ourselves, some things which are very sensitive and very personal, right? How many members of your family are there? Tell us a bit about your children, And in my mind, I didn't want to do that because it was my enemy sitting across the room. Why would I want to do that? How is this relevant? Those sorts of thoughts cropped into my mind. And in fact, I was thinking in my mind while all this is happening, why do I need even to do all of this? Why am I appearing vulnerable by sharing things which are so dear to me, right? In dispute where the other side, the other person sitting across the table is for all extent regarded as my enemy. And then the substantive needs, like, we were looking for a way to close a settlement. And, in mediation training, in negotiation training, we always say, once you have explored all your options which satisfies respective parties' needs, their interests, you weigh that against your alternative, right? And in theory, at least, if your alternative is better than your best option, then, it's hard to then argue that you should force yourself to accept the best option on the table, because the other road that leads out away from a negotiated settlement, if that's better, why should you settle? And so again, in this case, while the mediator was trying to persuade all of us to settle, I found it difficult to say that the best offer on the table was superior to the desire to get retribution and vindication. That was so important. And then at the end, question of the psychological needs, the mediator expressed the desire for parties to restore relationship. And I must say that was the last thing in my mind. Why would I want to restore relationship with the opposing party who I regarded as someone who was out to harm me? So all in all, when I looked at this from the framework of the triangle of satisfaction, I began to understand that it made sense to me why I exited the mediation feeling very dissatisfied with the process. And maybe there's a learning lesson there that, while mediation is a great way to resolve many kinds of disputes, I would say at this point of my journey as a dispute resolution practitioner, it is, in my view, not a panacea for all disputes, right? There are clearly sometimes other processes which people need to think about and explore. We are all, I think, here to discuss mediation because we love the process, we believe in the process, but I think we mustn't lose sight of the fact that mediation works in certain kinds of cases, but maybe for some other kinds of cases, we need to explore other processes, right? So that was my learning as a disputant. Now, I'm going to quickly just share my experience as a counsel and two short stories, right? Which to some of you may seem very funny, but these are real stories that actually happened. In fact, sometimes when I look back, I scratch my head and think, really, how come a mediator who is accredited and certified would behave this way? But I think as Adi pointed out, sometimes it's the practice, right? Notionally, a lot of mediators have gone for training, and in the abstract, they understand what mediation is about and how they should behave. But sometimes in the course of mediation, they let it get ahead of themselves, and they fail to appreciate that it's all about the parties in front of them, not about them. So this case, in the midst of mediation, I said to the mediator, because my client said something very personal, I said we would want to have a private session, something very important to speak to you, the mediators, in a private caucus. And to my surprise, the mediator said, no, I think this matter should be discussed openly. Why should it be in secret? And I said, no, but that's when I started to wonder, I wonder which training center he received his training. But I bit my tongue and continued to just present myself as with respectable mediation advocate and say, I don't agree, but can we please ask you for a private caucus? And again, he disagreed. And then finally I said, well, look, and I wanted to test this out because I wondered how far he would go. I said, if we cannot have a private caucus with you, then my clients may not be able to continue with this mediation. And then that's when he said, fine, then so be it, we can close this mediation. I hope none of you have this experience, but it was a very troubling experience for my client, and I was getting very upset by that time. Happily, immediately after this, he called a break, he cooled down, and we were able to continue and eventually resolve the dispute. But it could have gone very badly, and I would have said it had gone badly and the mediation had discontinued. It would, I think, to a large extent be the conduct of this mediator. What's the quality here that's involved? I think it would be the lack of quality. If we can expand and talk about what exactly we think he did wrong, but you know, from a very visceral user standpoint, I don't think that most of us in the discussion today would say he did the right thing, right? There's clearly something wrong. Now, case 2 is not a difficult case to understand. It's a typical case where there's a contract dispute. One party, my client, is claiming for contract sum for work done, and then the other side is claiming for breach of contract. There's a counterclaim, and then we were going on and on about negotiations. And at some point, you know, when you're engaged in distributed bargaining, right, bargaining that is zero-sum game, each party giving up a little bit, compromising, you usually reach a point in most distributed bargaining where there's an impasse, and that impasse needs to be bridged. And usually one would train people to say, well, when you reach that impasse, you need to go deep into exploring what exactly are the underlying interests, which needs to be unpacked and understood much better. We had 2 mediators in this case, and they were all seated in the main room, and they keep asking us to come to their rooms rather than to come to us. And what was very disconcerting was that mediator 1, who was a very senior practitioner, kept telling war stories. I mean, it's very nice, right, that if Adi and I have a nice coffee together and we share war stories, I'm sure we'll be very happy with each other. But here's where we want the mediator to engage and help us move away from the impasse, but the war stories were just going on. And mediator 2 was deferring to mediator 1 because mediator 2 was a very young practitioner. And at the end, I think the only thing I remember that mediator 2 saying is that, well, can I let the other party know if they're not prepared to pay you, then we are going to discontinue this. I think hardly the kind of intervention that I expect. My reflection on this case, yes, Nataliia, and I'm out of time. Thank you.
You have some minutes to conclude, please.
Okay, and I'm going to close with the end of this story. So my reflection as a counsel in this case, as a lawyer in this case, is that I think it's so important to remind ourselves, beyond the statistics that you will read, I think beyond the theories that you will read, I think all of us intuitively, if you are a mediation practitioner and you know what all of this is about, right? We are there to provide kindness, empathy, humility, and energy to the parties. I mean, those are things we do on a daily basis. We want to be people to be able to help others, and within us, I think, is the DNA to be able to do this well. The training helps us with the process, but internally, we must have that character and personality to do this. I just felt in this case, the mediators had forgotten what their role is, and they behave as judges. So again, if you look at the triangle of satisfaction, what didn't work? Well, I think that for the case 1, the mediator didn't attend to the procedural needs. Substantively, I think they were too stubborn-minded. The first mediator refused to accept the suggestion to go into a private caucus. And psychologically, I think they need to understand that when a party asks for something, it is because it is important to the parties. Case 2, similarly, I think what I want to draw out is that if all of us are doing this enough, sometimes it becomes like a business as usual. I think we need to remind ourselves every case that's given to us is a privilege. It is a privilege because parties hand over to us a dispute to say, please help us. And it is never business as usual. Every case demands our 110% attention. And so it is on that note that really I want to stop. The survey, I invite you to look at it. I just want to go right to the end and share with you this very nice picture. It is a Aranda, which is an orchid, name of an orchid, Singapore Convention on Mediation. The first time that a mediation is named, an orchid is named after a convention. And it's a lovely orchid, but it does bring me to also end on the point that in the Singapore Convention on Mediation, of course, now there are articles that talks about quality, it talks about standards of mediation, standards of the mediator. And we need to think a lot about this now, because when more and more countries sign into the Singapore Convention, that will be the hallmark, the standard bearing of what comprise a good quality mediation. So for that note, I thank you for the opportunity to share my stories. I hand this back to you, Nataliia. Thank you.
Шановний пане Ліме, я дуже
Dear
вдячна
Mr.
за
Lim,
вашу
thank you very much for this
презентацію.
fabulous presentation. And this approach with this triangle, it helped us understand so much all the details in those cases that you alluded to. Dear participants, we have multifaceted and highly professional panel discussion, which will help us take different views through different prisms at the issue of mediation quality. So, dear participants, organizers of the forum, I think this is a brilliant opportunity to listen to the speakers' presentations. So I highly recommend you to do the follow-up and read the presentations again. They're available. We shared them. You're gonna find unique professional experience and very useful information. Please, Mr. Lim, stay till the end of this discussion. I had to tell you actually before that this panel discussion, in terms of the sequence of speakers, was pursuing an alphabetical order primarily. And presently, I am honored to give the floor to Kateryna Narovska. I can tell a lot about her, or I can tell just a few words. When just using few words, I have to say that a lot of things are taking place with mediation in Ukraine, and a lot depends on Kateryna, because she's a great professional. And also, she is the president of the National Association of Mediators of Ukraine. She's a partner of sense-to-sense communication. She's the mediator, supervisor, trainer, lecturer, facilitator. She's masters of she has master's degree in law. We know your slogan of the academy, and you know that mediation should be in the hearts of ourselves. I'm sure that's the case, at least with Kateryna, that's for sure. So the floor is yours. Thank you so much, Nataliia, for these warm welcoming remarks, and I have an honor and privilege to join this meeting. I want to thank the Ukrainian Mediation Academy, our long friends and partners. They've done so much effort and invested so many contributions into the mediation developments in Ukraine. I really admire this forum. And this year, indeed, this quality issue in mediation has been naturally ripened, so to say. I think a lot of the words have been already said about what affects mediation quality. And like Nataliia suggested us to think about the number of issues to set the tone. We were thinking about this, and now we're going to deliver something. We want to thank our international colleagues as well a lot. I don't have a prepared presentation, but I'm going to share some of the insights from my past experience and what I thought about in preparing for this forum. I'm talking about mediation as a procedure, but how can we measure the quality in this communication within the parties? And I'm absolutely in favor of what Adi and Tat said. Many things affect quality because that's something that's going on in mediation. Of course, that's training, that's practice, that's support from the peers, knowledge, experience, and expertise, expectations of the parties as well. But one can definitely stress mediation quality is affected by three major elements. This is understanding mediation, understanding its essence, training, and that's what depends largely on the schools, traditions, the culture, where the mediator operates. And then again, like Adi said, it depends very much on practice, on the practical experience. And that, of course, contributes greatly to mediation quality. I love exploring other forms of thinking and other schools, and I really love understanding mediation as a complex system. Because any system that involves people is always complicated. There are no linear or direct dependencies. So one depends on another. There is not a causal linkage. There are so many different alternatives that affect mediation quality. But in fact, mediation as a service, what has to be reminded, this is something that is consumed once delivered. And a lot of attention is normally paid to this issue when we talk about mediation, that we should not guarantee and cannot guarantee the results. We do not suggest solutions. We cannot be responsible for the outcome. We cannot guarantee that the parties will agree and reconcile, but we want to make sure that there is a proper quality on our end. We want to help as much as possible so that people agree. For me, mediation quality is measured by one feature, which talks about skills and abiding by the principle, first of all. And I think if this minimum requirement is there, we can already talk about quality. But I would not consider the quality issue in just one thing or another. It's high quality or no quality. I would just say about the share or percentage of getting closer to the ideal service delivery in terms of quality. Can you hear me well? Because I have slight connection issues. Well, yeah, we can hear you. Great. So I would be talking about the following fact. Regardless of the school, the culture, advantages, practice, there's always this minimum requirement that makes mediation the mediation. There are certain benchmarks below which it's no mediation any longer. We try to do monitoring, we think about quality, and all that is primarily focused on ensuring best quality possible. On top of that, we want to make this process as useful as possible for the parties. And that's the results-based approach. Now we can come to another topic or dimension. Honestly speaking, getting closer to the ideal, the more we practice, the more I know what the other peers are doing, the more I have marketing advantages, respect, more clients, more opportunities to influence the society and our occupation as well. If paying no attention to this, then of course we're going to be annihilating the quality and there'll be poor interest to mediation. If we fail to monitor quality, we turn our blind eye to it. We need to engage associations, centers, training schools, because they all contribute to building trust to our occupation. And I want to thank Adi for making a very successful presentation on the quality matters. The main reason why we're talking about mediation quality is to be clear. Is that what's going on between the parties? Is that mediation or not? Genuinely. And also we ask ourselves the question, are we genuine with our clients or not? Or we pretend to be genuine? So mediation, this is about a lot of things. This is about ethics. This is code of conduct. This is behavior and careful use of those skills. Because of course, all these things can affect people. So we as professionals have to be really careful not to add something from ourselves to the parties, but also try to reveal their interest and try to reach a consensus solution for them. Unfortunately, there's connection quality problem. There's probably no more electricity on the Kateryna's side unless she reconnects. Then we will just pass the floor to the next speaker because, oh yeah, Kateryna is back. Great, I'm very sorry. I thought you could hear me. Sorry. Thank you for being patient with me. We only missed one sentence, probably. Not a problem. I was saying that trust mediation is contributed to by every mediator, every center, every association. That's why that's the attention we need to pay, and we need to keep the focus. Nataliia, you were asking in the very beginning what a quality mediation really is. To me, this is when all the principles are there, ethics, rules, and the parties themselves realize and recognize their own needs and interests. And at least they receive something that would enable them to make a conscious decision. If that is reached, then it means the mediation is of high quality. From my own practice, I can see that the parties may fail to understand the interests of themselves, not even talking about the interests of the other party. And sometimes, due to confidentiality, they may leave mediation and start negotiating on a bilateral basis. or sometimes solutions are not friendly, far away from being amicable. But the most important thing is to be conscious, make sure that solutions are safe and realistic for every party to fulfill. So when talking about mediation, it's very important to see those ingredients that make a good mediator a really good one. So this mediation community in Ukraine has paid so much attention to those issues. Starting from 2016, we've had our Code of Ethics introduced, which was amended in 2019, and a lot of contributions have been done by the Ukrainian Mediation Association. And before the full-scale invasion, we updated the Code of Ethics, given the law that had been passed on mediation before. So we were working hard on all those documents, and starting from 2019, we have the key pillars for mediator training, and we have all the competence-based chapters dedicated to training our professionals. We now have occupational standards, where the business mediation standards are in the pipeline. But all those documents, and I have to stress this, they are pure recommendations and not mandatory. I have to remind you that this is quite a creative occupation. So the combination of competencies, can you hear me?
Дякую. Поєднання компетентностей,
Combination of
поєднання
competencies,
шкіл, поєднання методик,
learning, methodologies, and tools that we engage means that this is a really creating process. So it's very difficult to develop strict instructions for the mediators. This way, we're going to limit the mediators themselves. That's why I'm talking about those lower benchmarks that we cannot dive deeper than if we want to ensure proper service delivery quality. Again, when we're talking, who is supposed to monitor everything? Who is monitoring the quality of mediation? And who is checking the mediator's qualification? Then again, there should be a system in place. As for me, this would be an association of mediators who should do that. These are the cohorts of professionals that can help share information, manage the learning experience and knowledge. They can support, supervise, intervise, consider some of the ethical challenges or complaints against mediators, or maybe there are questions that appear during the practical application of those skills. This is a quality assurance body, I should say. And like some of the documents say that we discussed yesterday and today, we therefore, where possible, build best practices. We have certain norms, certain requirements, aspirations, expectations, behavioral things that can support mediators. Another quality assurance measurement, this can come from the parties as well. And I'm thinking, what's first, chicken or the egg? The first decision on the quality has to be made by the peers, mediators themselves, or this can be done by the parties. Like Tat mentioned, this mediation success triangle is really great. If the parties are satisfied, if they think the procedure is fair and comfortable for them, and they manage to build constructive dialogue during the conference, and they found clarity of their positions, they understood the needs and interests of each of them, then this means the mediation was of good quality. And here comes the question. I understand we can put in doubt the mediator's qualification. Or can our consumers tell that my quality is good enough or not? Because the Ukrainian law says the mediator is supposed to demonstrate best behavior according to the Code of Ethics. He or she has to demonstrate there is a law on mediation, tell about mediation and how it works. And then people will consciously say whether all those elements in the triangle are satisfied. Then the third party, which is important to be involved in measuring mediation quality, is again stipulated by the law of Ukraine. This is a whole range of different entities like civil society organizations, mediator associations, government agencies, companies even sometimes that involve mediators. local government agencies, so any legal entity involved in mediations or involving mediators in their cases, they, by the law of Ukraine, have the right to set requirements for mediators. Like in the previous panel discussion, we were talking about IP mediation. It was alluded to that only mediators that are proficient in intellectual property are supposed to be engaged in those mediation sessions. So therefore, those clients normally look for mediators, and they normally say, okay, we want the mediator to have additional skills like awareness of the IP regulations and have experience in that. So they have the right, therefore, to monitor quality and decide on whether the mediator has successfully showed good behavior or not. Again, there are questions of accreditation. Accreditation is not a diagnosis. It's just feedback. Okay, my practice is recognized as that having good quality, and I'm perceived as a good quality mediator. Or if we are part of the IPO register, if I'm registered there, that means I have trust. So the mediators themselves cannot influence mediation quality because this is their job. There should be a third party to tell that the mediation is of good quality. I'm going to share some of the useful materials that you will find on the Padlet. First of all, there is one document, and we discussed it partly today, regarding training and skills. This document was supported by MATRA, which is the Mediators Association in Ukraine. We presented these outcomes in the last year's conference. What this document talks about is what's important to take into consideration whenever we train psychologists, mediators, lawyers, who are sometimes needed in the mediation procedure. We need to build proper understanding among professionals to contribute to the better quality of the procedure. Here you can read about some of the challenging issues and recommendations. So we found both gaps and delivered recommendations to this point. I will also share a presentation that was prepared before. I was at the conference this May. This year, you can see there's a lot of attention paid to training and mediation quality. So this presentation talks about quality assurance issues, and we were considering how quality assurance evolves, what kind of development trends there are, and how quality is assured from the standpoint of mediators and other parties. Because we were talking about building conscious and sustainable and informed demand for mediation. We were talking about quality assurance again, and what are the avenues that can help us take care of the quality matter. We partly discussed this, but there are many more details in this presentation. There is also M&E possible templates or procedures like monitoring and evaluation. You can also read about the current status and gaps in the mediation as troubleshot by the mediators themselves as the community. And you can also read about the next steps that we plan on this path, what we want to take care of, and what we're thinking about to implement. I think I managed to fit my presentation or my intervention into the 20-minute limit. Oh, thank you very much, Kateryna, for demonstrating this comprehensive picture of how mediation looks like and what mediators are doing as a community. And me as a person who, even though is not a mediator, but I'm so much engaged in these processes. I'm so proud of this, what's going on. And I'm really impressed from those people who try to develop their occupation in spite of anything, literally. And this
впевненості, що
brings
дійсно
me a lot of
медіаторська
confidence
спільнота
that
привнесе
the
суттєві
mediators
зміни в
community
наше
may
суспільство,
foster a real positive
які
change in our
тільки
society.
стануть нам на
And
допомозі.
I'm sure
Тому
mediation
я
is going to
дуже
help in so
вдячна
many
особисто
different
за ваш
areas. I want to personally
виступ
express
та
my
ці
gratitude to
міркування,
yourself for your presentation, for your
які я
thoughts and
особисто
ideas.
хотіла почути.
And I personally wanted to
підготувала
hear them
приблизні
from you. That's
запитання,
why
але
I
я
roughly
впевнена,
outlined the
що і
topics
вся
that I
наша
wanted you to cover
аудиторія
in your presentation. I'm
повинна
sure
і хотіла
this
почути
entire
саме
audience
це. Я
really
дуже дякую.
appreciates what
Прошу
you have told us
залишатися
about.
за
Thank you.
Дякую, пані
кінця.
Наталі. Одну
Please,
фразу
thank you, Natalia.
ще
Just
собі
one last thing I
дозволю.
wanted
Це,
to
мабуть,
mention.
одна з навичок
This is
медіаторів.
probably one of the
Побачити
mediator's
в складних
skills.
обставинах
In,
можливості і
in
підсвітити
every
їх.
crisis
Дякую, що ви дали мені
situation,
можливість це
please
зробити.
try to see opportunities and try to
Дякую.
explore them.
І нашим
Thank you,
наступним
thank you. And our
спікером
next
буде
guest
пані
speaker
Ірина
will be
Федорович.
Irina
Вона
Fedorich.
представляє і свій
She
особистий
represents,
досвід як медіатора,
she's
як
going to represent her
науковця, як
own
супервізора
experience as a mediator,
медіатора,
as a scholar,
як
and a
співавтора та
supervisor.
тренера навчальних програм
She's the
підготовки
co-author of so
медіаторів,
many different
супервізора з питань
curricula
надання
to
допомоги у
train mediators.
забезпеченні доступу до медіації у
And she
системі
has been working a
безоплатної
lot on
правничої
access
допомоги.
to
Вона
legal
виступає
aid and
експертом у
mediation.
питаннях
She's an
міжнародного
expert
правосуддя
in
у
restorative
співпраці з
justice
громадською організацією
as she
«Фокус права»,
cooperates
але
with
також
the
і
number of NGOs.
буде говорити, як я
And
відчуваю,
she,
про
as
досвід
much as I feel, she's going to be talking
сімейних
about the
медіаторів
experience of Association of the Family
де
Mediators in
пані
Ukraine,
Ірина виконує
where
обов'язки
Irina
голови
is an acting
правління.
chair of
Пані
the board.
Ірино, вам слово.
Irina, the floor is
20
yours,
хвилин.
please. 20 minutes,
Дякую,
please.
Наталя. Коли
Sure,
я це
Наталія.
писала, я не знала, що ви це все будете зачитувати, так? Тому
When I
я
was
би
writing
зробила
about
дещо
myself, I
коротше.
didn't know you would be
Насправді, я
reading all
сьогодні
that
буду
about me.
говорити саме,
Actually, I'm going to be
як
talking
виконуючий
about
обов'язки голови правління
our
асоціації і про досвід
association
саме
of family
асоціації.
mediators, and I'm going to tell a bit
Перш за
about
все,
our
дякую за
experience.
запрошення.
First of all, let me
Я
thank you for the
навіть сьогодні
invitation.
з задоволенням
For me, this is a great pleasure and
дякую
privilege to be
Луїзі
here.
і
Thanks,
Українській
Louisa
академії медіації
and
за
the Ukrainian
постійні
Mediators
постійне
Academy
партнерство, адже
for
по
a
всіх
reliable
процесах,
partnership
так,
that we've
далі
been
навіть
enjoying for so many years.
працюємо разом із
We all work together. That's the most
Національною
important thing,
асоціацією
together with the
та
National Association and the Academy and all
дуже
other
легко,
institutions.
насправді, бути зараз вже
It's so
четвертою.
easy
Правда, коли
to
Наталя
be the
сказала
fourth
про те, що
speaker, but when Natalia
я
said
прям
that we
напружилася,
are
хто буде
going to
перший,
be
я
in the
чуть відтягую,
alphabetical
щось
order,
змінилося.
I was not
Але,
quite
значить,
sure whether I
стараюся.
go first or Tatiana.
Власне, буду тоді опиратись теж на те, про що
Or,
говорили
sorry, or,
колеги.
yeah.
Аді сказав про те, що без
Adi
практики якості
said
не
that
буде.
without
І
practice, there will be no
тут
quality.
я на хвилинку екскурс
And
в історію,
I want to
як
give you a bit of
виникла
background
асоціація, тому
information
що
how we built this
питання якості
association.
це
Because the quality
одне
assurance
з
issue is
причин
one of
створення
the
асоціації.
reasons why we decided to establish the association.
Скажіть, будь ласка, чи видно повний
Can you
екран
see my
чи ні?
slides? Is it full screen?
Так, прекрасно.
Повний.
Hope
Все
so.
ок.
But it's not, but it's fine.
Отож, асоціація сімейних
Already.
медіаторів
So the
України
Family
була
Mediators
створена
Association
у
was
2019
established in
році, тобто ще
2019,
до прийняття
even
закону
before
про
the
медіацію.
law on mediation was
Проте, мотивом
adopted.
до її створення метою була
But the
відповідь
key
на потребу
motivation
сімейних
was
медіаторів,
to respond to the needs of family mediators as practitioners, to put together all the best practices so that we do not develop in silos as professionals, but we wanted to foster some rules and best practices in mediation. Therefore, the association supports and fosters both individual development and development in the teams. Because every mediator, as we consider, is a personality. So we have standards, we have quality assurance mechanisms, we have awareness raising and collaboration. We disseminate information on what mediation is among our potential clients. And here you can see those key objectives. Like I said, that the association we're only going to talk about quality assurance. What's important from the quality assurance standpoint is that the association members are representatives of various entities that deliver mediation, and also those who do training for mediators, as well as practitioners. So the association does not deliver the services itself, but it is founded to develop and pursue policies and encourage advocacy. Tat mentioned already that we perceive quality differently depending on where we are. whether we are the mediator, or we are a client, or we're the state, or we're an association. But in conflicts, there are several professionals involved, lawyers, mediators, and others. As we were taught by Mr. Shapiro, he was one of the guest speakers at the conference. Actually, there is no information vacuum. Unless we build understanding of what quality is, what a quality service is all about, then we're going to have siloed understanding of what quality really is. So I think this topic is not only important, but is super important and key, because today's mediation market is evolving really fast. And what I'm going to talk about is how the association works and what we do. We not only analyze current legislation, but we also try to respond to the practitioner's requests. We analyze risks and challenges, as well as gaps in building trust to mediation in general. What we do today, apart from pursuing our main goal, we run a project which is called Avenues to Fairness in Resolving Family Conflicts. We're supported by USAID, by the American people, through the Justice for All program. And what we want to is implementing best practices and recommendations from the Council of Europe's Mediation Committee, CEPEJ. And if we go to the scope of these documents, from the quality standpoint, these are the founding documents for us. The recommendations are about that for the state, it is important to implement decent mechanisms of selection and training mediators in full accordance to the standards that are going to be supported by the mediators themselves. And the guidelines, number 14, for the best implementation of the recommendations were based on the analysis of problems and gaps that sometimes take place in various countries in the development of mediation. There are different approaches to training mediators, and there's different understanding of the mediator's role and functions in resolving disputes. From the quality assurance standpoint, I have to mention that quality is so important for everybody. Nobody denies that. First of all, this is important for the parties and also for us, the professionals. Every time when a judge refers a client to mediation, the judge needs to be sure that there will be a quality job done by mediators themselves. And a quality cannot evolve by itself. It has to be based on policies and rules. Again, with regards to how to ensure quality and how to monitor this, these international papers also mention a lot about training. They make a lot of emphasis on building competencies. Because one thing, you pass the training, but it does not guarantee that you're going to have good skills. So that's why mentoring and monitoring, these are the things that have to be ongoing. You cannot just measure once and forget about it. This is a constant process. And the mediation law in Ukraine is a framework legislation. It fully complies with the CEPEJ recommendations and guidelines. It also describes the mandate of the mediator, training, quality standards, and service delivery standards as well. Because we therefore consider family mediation as a separate, specialized thing. But like I said, the law is a framework legislation, so it gives enough room for all the professionals to rely on it. There are requirements to professionals, and therefore policies can be built on this basis. So what do we do? What we managed to do and where we are going? First of all, back in 2020, the association involving partnership organizations and mediators, practicing mediators, who were ready to join us, we developed foundations for developing basic skills of a family mediator. I'm translating literally. I think for all the mediators, it is important to understand that quality is not something constant. This is something that we need to review, assess, evaluate, and monitor. Thanks to this, in 2023, we realized that those founding principles have to be reviewed and amended. It was not a simple and easy process. It took 2 years to at least review them and update them. So now this is our next step to update all the basic skills for exactly family mediators. Again, in 2021, we developed a number of recommendations of how mediators should act in cases they find family or domestic violence cases. One of the first tools is how to screen the situation, because we know that in family conflicts, very often there is family violence. And it's important to understand what it's all about, how bad it is, and how it can affect to creating disbalances of powers, and how it can affect the success of the mediation procedure itself. So these recommendations give certain course of action to a mediator in case he or she finds those facts. Those recommendations were reviewed already this year, so we keep everything up to date. And apart from this, we decided to go even broader. Every time when you do something, there's always a danger of limited views on something. You can sometimes remain to be in your own silo and you focus on some of the things, but may forget about something else. That's why we wanted to take this holistic approach. That's why we engage so many different professionals. Right now, we work closely with UFEM. This is the female non-governmental organization that is focused on protecting female rights. So we were talking to them and a number of other partners to see if we are holistically approaching the issue and if the recommendations are comprehensive. Another thing that we've developed already under the project that I mentioned before, these are the rules of family mediation. So those mediators can actually take this as basis. This is done for our community, for the association itself. They're no good for those who do not deliver mediation services. They're purely professional. And this is very good for your individual training, because you can read those rules, you can find the mediation agreement templates. So this is a really helpful tool. And specifically for our international partners, this is a document that combines methodology and the procedure itself. So we reflected approaches that a mediator can use and the structure of this entire process, how it should be delivered, as well as the expected outcome. Now, moving forward, the association also produced a draft professional code of ethics in family conflicts, and also the regulation on accountability for the violation of professional ethics. This is really important for the National Mediators Association. If I'm not mistaken, last year, the association organized an extremely important training for the entire community, thanks to MATRA project on professional ethics. Thanks to this training, we had an incredible number of mediators who expanded their minds and improved their attitudes to the different ethical norms. In the course of the discussion last year, we realized the family conflicts have something specific. They're not like all the other cases, because sometimes these cases involve children. Very often this is the case. We also sometimes face family violence or domestic violence, and that had to be reflected in the code of ethics. Like Kateryna mentioned today already, the mediation law in Ukraine provides for a commitment from the mediator to, when preparing for mediation, always be mindful of the code of ethics. For us, this is another means of communication, how to deliver what mediation really is and how an individual can work with expectations. So this is something that we've done. We'll also develop this kind of accountability clause for any kind of violations of professional ethics. So we were working hard, really, on the draft. There were several drafts, actually, and then we had to come to a common denominator, so to say. And probably one of the most expected and interesting document for our organization will be the mediation service delivery standards. We're working hard on them. Right now, this is a work in progress, and we are still discussing this with our members. You know why this is important? Because according to the mediation law of Ukraine, mediation has to be delivered in full accordance with the law, mediation rules, professional code of ethics, and a mediation agreement. So many things have to be taken into consideration. That's why in our standards, we included the following scope. This is going to be a document which will combine best international practices and experiences from all those founding documents. Looking into the future, how this document can look like, we envisage that it will include several parts of provisions, groups of provisions, where there's going to be the lower level guidelines, it will be the discretion of choice, which includes normally the word may, but not must or should. It is good too, then the other part, which gives even more discretion, and we have to be careful there because that part may pose certain risks because it can be interpreted differently by many different professionals. Most of the people will probably rely on the law itself, but we have to be mindful of the other documents like guidelines, recommendations, and best practices. So we're trying to actually put together all the experiences that we've had so far and develop something really tangible and consolidated. Another really valuable and probably the most complicated document that we've been working on, this is the accreditation procedure. We started this work even before the full-scale war. It seems like so far ago. But due to the war, we had to suspend our work a little bit because our stakeholders and partners had to move somewhere else. Some of them got displaced. Now they're coming back, and we again continue this work on the accreditation procedure. Once we're ready, we're going to definitely share it with the entire community, including our international partners. Like Kateryna mentioned, this is for us a document of recognition. And for us, this is very important because mediators will have to sometimes monitor their own practice. You were talking about specialization and accreditation. Yes, we have the procedure for specialization, but there is not yet a procedure for accreditation. Again, you have specialization in the registers and special training requirements. So there is something to rely on. But with accreditation, it's going to mean that an individual passed the relevant training, and then the occupation can be confirmed by a certificate. But accreditation is even greater. It means the individual complies with the practical requirements. Only those mediators will be accredited whose practice will be verified and confirmed. So in order to provide even more guidelines for their professional development, that's the important document, because in the law you do not find it. So we decided, let's think how we should enhance professional development of family mediators through our association. We love developing documents, as you can see. And this is because our mediators always want that. They want to analyze their own practice. They want to monitor it, borrow best practices possible. That's why we decided to create this document, which will help mediators to figure out whether they're good enough or not, whether they can be accredited, and if so, then it means their practical skills and good service quality are confirmed. So it will be our association will be taking care of professional development. And last but not least, I have to say that we are now running a survey among mediators regarding their practical experience. This is so valuable for us. We have very little statistical data today, and there's no reliable information from the practical standpoint. So with this survey, we want to investigate best mediators practices, but we also communicate a very important message for lawyers, judges, and our clientele primarily. So we survey also our clients, and when the findings are there, we will have a clearer picture about what's going on. The survey methodology was borrowed from the legal aid system, because they had been doing these surveys for many years before we started. So these legal aid centers help us a lot in this survey. And also, it is important to mention here that last year we had 2 competitions to select best mediators that work together with legal aid professionals, hand in hand. We cannot discuss this experience right now because there's very little information. We're going to get more once we are done with the survey. If there are people who participated in the competition, you can then share your experience. So legal aid really helped us create this valuable and precious experience in verifying occupational skills. And there is a special decree that sets out the procedure of confirming special skills for those mediators who are engaged in restorative justice. This is a very valuable result. So we are waiting very much for the survey to be completed, and then we're going to share the outcomes. Okay, I want to thank you for your attention. And the only thing I want to add that sometimes we can hear from the outside, and Adi mentioned this, sometimes standards and rules can be perceived negatively by the community. This is something that limits ourselves, people say, or this is too formal for me. But if those are developed in the spirit of trust, support, and professional development, then I think there's going to have much more buy-in from the entire community. Thank you. Kateryna, thank you so much. I've been always observing this phenomenon of the Family Mediators Association in Ukraine. They're really the most productive ones from the standpoint of developing so many different documents. They had a special admission procedure that they had developed, first of all. Then we saw so many other developments. So we really appreciate this. This association, I understand, relies heavily on their own experience and international best practice, and gradually you implement all this. As a scientist, I highly welcome this. I have something to analyze now, and I appreciate that, really. Thank you very much. I'll take note of that. So we're going to do more for you. Regarding your last statement regarding the importance of rules, documents, and standards, I would like to add something. They also create more transparency and predictability of the mediation procedure, especially for the parties, I think, which is also an important contribution to developing mediation and building more trust to it. And this will probably reduce conflicts against mediation. So when we're talking about mediation quality, it can be poor quality? Can it? Yes, it can. And thank you for this remark. I've taken note of that. I have so many notes after all the presentations. So to continue this idea that you just mentioned, for me, this perception that mediation quality is always linked closely with the agreement, it's not always the case. That's why we design so many different rules and regulations. Okay, we have one more remaining brilliant speaker. I already told you about the multifaceted nature of our panelists, and it is my pleasure now to give the floor to Tatiana Tsuvina. She'll tell herself if she is more a mediator or a scientist, a scholar. Tatiana is a doctor of science in the law. She's head of the Department of Civil Proceeding at the Yaroslav Mudry National Law University. This is the university that opened its first mediation center for the first time ever, that Tatiana is a manager of. She writes a lot of articles about mediation. She is a lecturer. She delivers training on mediation, and she is the great speaker. Tatiana, who are you? A mediator or a scholar? Good afternoon, dear colleagues. First of all, I'm so glad to be here among so many respectful speakers, and thanks very much, Luisa and Nataliia, for the invitation. Starting from your question, Nataliia, I have to say that there's a struggle inside of me. Procedure, because I defended my thesis on the civil procedure and its principle, admissibility and fairness, and the mediator. They're both fighting inside of me. So I think I'm going to be speaking. So it's very good that my presentation is the last one, because I'm going to be trying to combine those two, a mediator in myself and a procedure expert. I'd like to draw your attention more to quality assurance mechanisms. Like my teacher, Professor Komarov, likes to say, substantive law is nothing without procedure. It is the procedure that ensures proper quality of mediation, in my view. So when I was invited to speak at this forum, I asked myself a question. What is quality assurance and what contributes to it? Speaking about mediation quality, I think there are several integral components that in its totality can assure proper quality. First of all, this is quality of legislation and standards governing mediation. I'm talking about the law of Ukraine on mediation, which is a framework legislation, but at the same time, this is also about those other acts adopted, and they're purely of mandatory or recommendational nature. These are the mediation rules that associations can use. This is the code of ethics. This is the entire pool of requirements that we can call together a standard. There's hard law and soft law. I don't think you understand me wrongly. I'm not a proponent of strict regulation, but still, when we're talking about quality, we have to be governed by certain standards, and we cannot help it. I mean, there has to be a certain framework, at least in principles, ethics, etc., but it has to be put down somewhere. Another quality assurance component is training quality, because it is important who is training and who is delivering the training and who are the trainees. Is the trainer capable to develop knowledge and skills necessary to do mediation in its students, in his or her students? Another one is service quality. This is the quality of the procedure, which is determined by the fact that an individual is trained, follows the rules, and that's when the synergy is there, that's when magic happens. But none less important component is efficient defense mechanisms. If you, for instance, received poor quality service, you need to be able to engage a remedy. The law can be perfect. The law can be quite liberal. We can do a perfect training and train a lot of mediators, but then at the end of the day, the parties may not be satisfied because the mediation was poor. So what are we supposed to do in this situation? We need to think. So all these components together, number one, standards, what mediation is, and how we abide by all those rules and regulations to tell if this is good mediation or not. And also remedies available when an individual is dissatisfied with mediation services. All these components together can make a mediation good and high quality. And this is when we come across so many different issues. How do we assure quality? Who is supposed to do that? And what the procedures should look like? Again, when speaking about external mediation, which is not integrated in the judicial system, nowhere else, then probably it's good that those quality assurance issues would be taken care of by the associations of mediators and professional cohorts. And again, when we're talking about mediation, which is integrated into government agencies, procedures, free trial, and in-court mediation, legal aid, or whatever frameworks. And we're here to talk about engaging resources from the state. I love those studies which focus on coercion mediation. And always this coercion, it is a coercion to mediation. This is when mediation is mandatory. Or sometimes there's coercion inside mediation. Sometimes people think it's not possible, but sometimes it is. Especially with mandatory mediation, it sometimes can take place. Some other people add one more component, coercion after mediation, when we say, you are now supposed to fulfill all the conditions of the agreement. You are the parties, you agree, now you're supposed to. You must follow all the provisions in the agreement. So, therefore, we need to take into consideration whether this is external or internal mediation. I mean, inside the system or outside of it. If the law allows, for example, to in case mediation is taking place in the court or it is organized at the legal aid centers, if there can be additional requirements to mediators, I think at the same time, a quality assurance has to follow all the time. Whenever there's a requirement, there has to be a quality assurance procedure. This is the way to properly manage mediation quality and complaints.
Ми можемо стикнутися з деякими
And here we can
питаннями,
sometimes
які
face
вже
certain issues
пов'язані із
which have to do with access to occupation and the possibility of sanctioning individuals who are doing a poor job, like to put a ban or suspension on professional activity. Let us imagine we have a dedicated body, an authority, which can manage complaints against mediators and can apply or impose sanctions. Maybe mediators will be banned or suspended or excluded from the registry or sent for retraining. In the context of Article 6 of the European Convention on Human Rights, this authority becomes like a court because it already rules on access to occupation. So, in the course of the convention, this authority's action can be subject to appeal, or it can be done within the organization, or we can sue this organization, this authority. And here there can be a problem. What are the guarantees that this authority has to provide? And here we come back to the first issue, legislation and standards quality. If both legislation and standards are not clear and not comply with legal certainty principle, then potentially we can face a danger when some of those actions of this dedicated authority will be challenged at court because there are no specifically developed grounds within legal certainty under Article 6. And here there can be so many questions. Like, is there the unity between the standard, which we take as the foundation, and the unity of the other mechanisms? I mean, accountability mechanisms. There is another issue that I wanted to draw your attention to. This is what we consider a good mediation or good quality mediation. We've been talking a lot about whether we can narrow down mediation quality to satisfied customers or clients, satisfied parties. I think it cannot be equal. Moreover, we need to ask a broader question. Mediation quality, whose job it is? Whether these are the parties who are responsible for it, mediators themselves, the associations, providers, or courts. Who shall be responsible for taking care of mediation quality assurance? If we narrowed quality assurance to satisfied parties, then we might face situations when, for example, the parties are dissatisfied because they couldn't reconcile. Well, we cannot say this was poor mediation or due to poor mediation. Or, okay, the parties concluded the agreement and used mediation during the trial to abuse procedural rights. The parties are great, the parties are happy, and then afterwards, these facts are found that there were actions by mediators and the parties to take advantage of mediation, not for mediation itself, not for its purpose, but to abuse the procedural rights. Then whose case was it? Is it the court who is supposed to control that or not? If the parties are happy and the mediator did a wrong job, can we say that this is a good quality service or not? If not, then who has to raise the issue? And who'll judge on this? That's why these many questions, there are so many of them. And there can be situations when the parties had unrealistic expectations and the mediator tried to do everything, explain the principles, demonstrated the code of ethics really well, but for some reason the parties could not agree. And here one can ask, where do I submit my complaint? If there is no single authority where you can go to, the association or whatever organization that you can file a complaint to, then there is only way to do it, to go to the court. The court will always take a formal approach, a formalistic approach to mediation. And then we again end up seeing the situation when the court becomes an entity to assess, to evaluate quality of mediation, because the mediators community could not encourage this complaint management mechanism. And what kind of conclusion can a court make? The court will grab all the legislations, all the regulations, etc., and depending on their quality, the court will rule on the case. But we can sometimes face a situation that the mediation it's going to be judges who will be ruling on the mediation quality in their case law, just because those disputes that sometimes are based on the mediation agreements, they will be reaching the courts very soon, I'm telling you. And I think by promoting mediation, by resolving conflicts, with no engagement of the mediators as the community and without the suggested complaints management mechanism, this can lead to a situation that we are going to learn many new things about mediation from the case law. But I don't think from jurisprudence, I was involved in the development of the mediation law. I wouldn't even think that this is what mediators really want, given the framework nature of the law itself, as it is now. And at the end of the day, to finish my intervention, I try to push this idea forward, and I'm going to tell you what the idea is all about. I want ourselves to think not only about standards, but also about mechanisms and procedures a lot. How we respond to poor quality services. What's the answer that we can give? I think if there are well-described standards, as it is seen by mediators, and acceptable and accepted mechanisms where one can go to in case there's something wrong, the available remedies, altogether this will help us reach high mediation service quality. In case we just have standards, we're going to be limited. This is not going to contribute to anything. The standards themselves cannot work alone. Thank you, Nataliia. Diana, thank you so much for your presentation. You are an absolutely ideal time manager. You raised so important issues that I am sure the entire community has to think about. I mean, mediators and mediation service providers and legal aid professionals as well as the judiciary, in case there is going to
Також я
be
б
mediation
хотіла
at
сказати,
courts.
що наші організатори роблять дуже
I have to
багато
say that
для
our
того,
organizers
щоб
have done so much
максимально зробити цей форум
to
корисним
make
для
this forum as
широкого
useful as
кола
possible for the
учасників.
broadest
Але у
circles of
випадку
participants.
цієї панелі я
But
б дуже
in the
просила
case of this panel discussion,
текст чату
I would
цього
really
форуму
like to
також
copy
долучити до
the
матеріалів.
chat.
Дуже вдячна
Please
спікерам та
add them
учасникам,
to all the
які
deliverables of
паралельно
the
вели
forum, because
дискусії.
many
Ця
participants
дискусія
had discussions in
стосувалася
the chat, and those
першу
discussions
чергу
were so
того,
important.
як я
Primarily,
розумію,
they focused
чи
on
є
whether
та фасилітативна чи
this
оціночна медіація
facilitating mediation
певним критерієм
is a
її
criterion
якості.
for
І,
its
по-друге,
quality.
наші учасники
And also, our
говорили про те,
participants were
наскільки
talking about
спеціалізація
how
медіації
much
пов'язана
this
із якістю
professional development
медіації. І,
affects
як на мене,
quality
це
and
були
or
дуже
contributes to quality.
важливі
And I think
аспекти
those are very
цієї
important aspects that we found
дискусії. Я
in
ще
this
раз дуже
discussion.
вдячна всім
Once
за
again, allow me to
таку
express my
чудову
gratitude to everybody for this
дискусію.
brilliant, outstanding
Пані
discussions that
Луїза,
we've
ми
had.
були найбільш
Louisa, we were the most obedient and
панелю, тому ми
organized from all
вимагаємо
the panels,
окремих відзнак.
so
І,
we want to be
шановні
rewarded for it.
учасники, у нас залишився час
Dear
на
participants,
дискусію.
we
Будь
still
ласка,
have a
піднімайте
bit of
руки,
time for
спікери
discussion.
готові
Please
вам
raise your hands,
відповідати.
and the speakers will be ready to answer your questions.
Я поки піднімаються руки, я хочу звернути
While people
увагу,
are
що
raising their
дійсно чат
hands,
це прям
the
багато
chat
всього
is
нам
something
потрібно
really
розповісти, то
wonderful.
у
There's
нас
so
має
much
бути
useful
таке
information there.
налаштування, що якщо ви зверху натиснете на три
So if you
крапочки,
press
то
the
ви
three dots on
можете
top of the
вести
chat,
цей
you can
чат
also
для себе.
copy this chat for yourselves.
Мгм. Дякуємо за
Yeah, there
нові
is one.
навички
Save chat.
користування
Thank you
Zoom.
for the new Zoom skills that you've developed
От бачу по
among
обличчю Катерини,
ourselves.
що є. Я так
Yeah, I can
поступово
see Kateryna
бачу
has managed it. I can
віртуальну
see more and
комунікацію
more
через екран.
people
Тобто так
who
спеціально
managed to save the
налаштували,
chat.
знали, що буде багато
Yeah,
всього
we
корисного. І до того, як
specially
ви завершите
set it up
збереження
that
чату, я
way
просто
that
надсилаю
anyone can save the chat
посилання зараз.
for
Це
their own
в
purposes.
кінці,
I'm now
це,
sharing the
мабуть,
link
Тат
with
ще
you.
зможе доповнити. В кінці
I think Tat will add
серпня
something. At the end of
відбудеться
August,
сінгапурський
there is
тиждень
going to
взагалі
be
медіації.
the
Це таке
Singapore
свято,
Mediation
яке
Week.
триває величезна
It's
кількість
it's
заходів,
called
але я
literally
ось просто
Singapore
посилання,
Convention
ми знаємо
Week.
багато колег, але мало хто
I know
обізнаний
a
про
lot of
можливість
people are willing
що
to be
це
there, and
відбувається
others may not know that it
цей
exists,
екран.
but
Я
now you
виходить
know it.
граюсь, я тільки про чат
So
хотіла
then I get
сказати.
disconnected. I only wanted to tell you about the
Добре,
chat.
я
That's
не
it.
встигаю, якщо
Окей,
чесно,
Наталія.
прочитати все, що відбувається в чаті, але чую
I
слово
cannot even
спеціалізація і
manage reading
розумію,
everything
що
that's
є
going on in the chat,
дискусія
but
в цій темі.
I can see that the
Я
discussions
можу
there is
просто
really
висловити
hot.
свою думку, щоб там
I
багато
can
не
only tell
писати, про
something
те,
from my
що
side, not to write a
є
lot.
різні категорії
There
конфліктів.
are
Я
so many
розумію, що,
different
мабуть,
kinds of
немає сенсу
conflicts.
дробити
I
кожну
don't
там
think it's
категорію на
reasonable
безліч
to consider
спеціалізацій, але
every
я можу
category
просто
and say we
опиратись
need
на свою
specialized
практику.
mediators
Якщо
in
ми
every
говоримо,
category.
наприклад,
I can
про
rely on my own practice.
відновне
When we
правосуддя,
talk about
то там
restorative
без
justice, for instance,
додаткової
without
підготовки
additional
курсу
training, one
це
cannot do it
великий етичний
professionally.
ризик і виклик. Тобто ми повинні
One
розуміти,
can
що
face a
законом
lot of
України про медіацію
ethical
не
risks.
передбачено
The
вимоги
mediation law does not
стосовної
require
підготовки,
to
тільки
have
забаганки.
specialized training.
Далі
Only
це
basic training is required.
питання етики медіаторів.
And now
Так,
then,
наприклад,
after it's
Асоціація
an issue
сімейних
of
медіаторів
ethics,
України для
the
себе
Family
встановлює
Mediators
обов'язковий
Association
критерій. Ми не кажемо,
sets
що
a
всі решта не можуть
mandatory
бути.
requirement
Для нас це
that
просто для нас,
people need to
медіаторів,
pass
які приєднуються для
family
асоціації,
mediation training.
наявність спеціалізованої
But this is
підготовки
just our
повністю
requirement.
і критерієм
We need to
відповідності, також якості. І тому тут
follow
мені
all
просто
the quality
здається, мені би
criteria,
хотілося почути
and
практика, який
I would
має
just wanted to
спеціалізацію
hear
і скаже, що
the
спеціалізація
practitioner who has
неможлива,
specialization,
це не
who is specialized in
допомогло,
something,
так? Тому що сімейна
and who can
медіація
say,
також, як
no,
відомо,
the specialization is
дуже
not
окрема
important. It never helped me
і
really
можна, і справи є
in
різні.
my
Є
own
просто
practice.
там про поділ, можливо,
There
майна,
are
де
simpler
тоді є,
cases,
але ж
maybe
є
when
там
this is
випадок
about
домашнього
property,
насильства,
that's fine. But
залучення
when
дітей,
in cases
де,
where there are
тобто, колеги, тут
family
тема власне для
violence
дискусії, і це,
issues,
напевно,
or
також
we have to work with
про формування
children,
інформаційного
it's really
забезпечення.
important to
Тобто
be
про це
trained
треба,
on
значить,
that.
говорити. Якщо не
At least we have to
зрозуміло,
raise the
про це
discussion,
треба говорити.
because this way we can only build understanding in our
Катерина, напевно,
community. Why this is
вмикається. Я вже
so
так
important. Kateryna, please jump in,
Це вже
because I
Наталю
can
не
see you raised
встигнемо
hand.
перепитати, чи можна брати слово. На самоорганізація
We
це дуже
cannot
висока
ask if we
навичка
can take the
медіаторів в
floor. We're
Україні.
taking the floor, grabbing and doing it.
Я
So that's
хотіла
it.
додати
All right, I
такий,
just wanted to
що
add one
для мене,
thing.
про якість це дуже багато
To
про
me,
безпеку.
quality is a lot
Про
about
безпеку для
safety.
самого медіатора.
safety for the mediator, him or herself, and safety for the parties. This is exactly why we're thinking and taking so much care of quality. To me, this principle, do not do any harm. That's the first thing. And that's the prism through which we have to look at special training. First of all, there has to be an arrangement, an honest arrangement between the parties, so that people understand what they can expect and what's the procedure that is going to be engaged. Secondly, there are cases where you just have to be a normal human being to try to reach an amicable resolution. In some other cases, though, without knowing some of the concepts, some of the terminology, a mediator may not even understand what those people are talking about, and the mediator's presence will be just not good, but bad for those opposing parties. Of course, you need to know early what's the issue that you're going to work on, so that you can take a balanced decision whether you are supposed to be there or maybe not. Maybe you can ask some of the specifying questions. Like in the family mediation, there is a list of questions. There's a preset checklist of questions that you need to ask before you go. So clearly, it's not an obligation to have specialized training for a mediator. But of course, this is an insight that maybe you're not supposed to be there and mediate. Maybe you're not good enough for this. Maybe you're not experiencing this. And in some simpler cases, like I said, you just need to facilitate the conversation. Again, like I said, this is an ethical issue. We need to be more careful and pay attention not to cross those boundaries and not to start imposing your own expertise at the same time. You can be a great expert in a certain domain, and you can be really biased. You can try to impose your own thinking on the parties. Can I just continue this discussion a little bit? Maybe our colleagues will jump in as well. There's an interesting issue. How to select a mediator properly? Mediators themselves can sometimes never answer this question successfully. The register does not answer this question. You can only find filters in the register. You turn on the filters, but it's not always very efficient. So can we suggest to a party, okay, here is the criteria. Given the nature of your dispute, here are the criteria that you have to pay attention to. Again, this is about one of the external quality assurance mechanisms, because this way we can contribute to better quality mediation. For instance, a client may not understand what mediation is all about. We need to deliver this information. This is not the service for us, but this is a service primarily for the client. Yes, thank you. And I would please encourage Tat Lim to tell something about it, because in the questionnaire that you wanted to share your comments on, these questions were there, actually, and the answers too. Please, Lim.
Yeah. And I'm actually dying to hear from Adi as well, but let me, since my name was called first, I think first and foremost, the people who are facilitating the mediation process, I think we mustn't forget the lawyers sometimes who come on board. And IMI, of course, has accreditation certification, not just for mediators, but also for mediation advocates, lawyers who are participating. And I think it's important that we embrace that eco-culture, that eco-environment, where we say not just the mediator should be trained, but if the parties and their counsel are also trained, then they would be able to say, in going into mediation of a family or relational dispute, here are the characteristics of the neutral, the mediator, that we would like to be appointed. And I think that sets the stage for a very helpful discussion on the right unicorn to be appointed as the mediator.
Thank you
so much for your answer, Mr. Lim. Adi, now we're ready to hear your opinion, please.
Yes, this is fascinating. First of all, let me congratulate all the panelists. The panelists, it was really, really interesting. Two quick points. First of all, I had two cases very recently finalized. One was let's call it a family situation with one-on-one, right? Two partners having a difficult conversation, and they needed support in the way they engaged in that conversation. They didn't want their lawyers to participate. They said, we just want to be us. We just want to have a conversation. And that ended successfully after a couple of meetings altogether, I would say a week or two. The other case I would refer to was a case that we settled in December last year. Tat, you may know this one. It was in Egypt, the biggest solar project in the world. They actually established the location with NASA in Sahara. 2.3 or $2.4 billion. It was a company community situation where it was different than my family situation, but it was also that I mediated with a colleague there, an Egyptian mediator. I use different skills. I use different techniques in these cases. So the point I'm making is that, you know, specialization perhaps could refer to the industry, could refer to the type of case, multiple parties, multiple issues. We may need additional, you know, skills to handle certain cases, although fundamentally the same key competency areas apply. So that's one comment. The other comment, very quickly, I will share my screen if I am allowed by Nataliia for 2 minutes, or not, no more, I would say, because there was a conversation about whether we can influence, can we bring our expertise, do we actually need expertise, subject matter expertise, and all of that. I think I may be able to help with a framework that I would like to share on screen, and I hope you can see my screen. I'm not able to see you, but that's fine. So this is basically, these are two axes. The process axis is the horizontal, and on the left-hand side is our low influence of our process, a mediator who asks the parties, do you want to meet together? Do you want to meet separately? It's up to you, you decide. Don't expect anything from me. A mediator who involves only the parties to make decisions. And on the right-hand side is Tat's mediator who said, no way, we're not doing any private sessions, even though he asked 3 times, right? So that is high influence of our process. And then, you know, it's up to us, it's up to the parties to have expectations, but we have to be aware that mediation, actually, it's not this dot here in the middle. There is an entire range where we can position ourselves. Whether we should or not, that's a different conversation. The vertical axis is the substance axis, where we can have a low influence or a high influence. This is, everyone, something that relates to expectations, parties' expectations, but most importantly, our own expectations. Let me make my point. Party 1 may want me to have a high influence over process. It may be that this is an employee engaging a manager, and the employee wants to balance the playing field, and he or she wants me to be high here in terms of process. In terms of substance, not so much. So this is what this employee wants me in terms of my position in this space as to the service that I will be providing. The employer may say, no, we're fine, we will define our own process that we want substance. However, we may need your expertise. This is what they want. They both want mediation, but they want different things. So in the preparation, I may want to spend time with them to basically clear these expectations and try to harmonize these expectations so they have a sort of a common sense in terms of what is expected of me. Unless I have that clarity in terms of what they expect and what I can realistically offer, it's very difficult for me to provide a service that will be fitting their own needs. So I just wanted to make that comment, because otherwise, if I start a mediation without even understanding what they expect, we'll all be talking about mediation, but nothing will be clear around who's expecting what and whether I'm comfortable offering. Thank you, Nataliia.
Дуже дякую за вашу
Thank you so much for this very insightful presentation. It was short but very efficient. A lot of the things have become very clear. We had some very interesting questions in the chat, but I think the discussion has gone
Ось
through
ще питання
some of
від
those.
пані
We
Світлани
have a question from
Стрільбицької,
Svetlana
питання
Strelbitska,
українською, тому я зачитаю, а
and I'm going to read
перекладач
it in
буде
Ukrainian, and the interpreter will do his
перекладати.
job.
Чи повинен самоусунутись
Should
від
a mediator
медіатора від
withdraw
процесу
from the
медіації,
mediation
коли
process
відчуває, що
if he or
надає
she
перевагу
feels
одній зі
that
сторін? Що
he
робити
has
в цьому
favoritism to
випадку?
one of the sides?
Тому
He
прошу,
is more in favor of one party versus the other.
медіація – це про
So
неупередженість.
mediation is all about impartiality,
Найбільш
objectiveness, and
неупередженим це
neutrality.
алфавіт. Ми будемо
The
за
most
кириличним
impartial thing
алфавітом.
is
Тому я
alphabet.
попрошу дати
So that's why we're going to
відповіді і,
follow the
можливо,
alphabetical
якісь
order.
фінальні
So please, if
заключні
you
слова
can give
кожному
your
із наших
answers.
спікерів.
I mean, I'm
Тому,
giving the
пан
floor to
Аді, вам слово, будь ласка.
every speaker now. Eddie, the floor is yours because your name starts with A.
Thank you, Natalia. I am sharing in the chat a link to a more comprehensive response for everyone to read. In other words, if I have any concerns with respect to my own neutrality and impartiality, I don't see myself having enough objectivity that my ability to keep, my position in that mediation is affected severely, I should excuse myself from a case. However, if I see a concern, but I see myself still okay, I should consult the parties, and then pending their decision, I should continue. In other words, this is what I call the ethical mediation filter. Feel free to read. Thank you, Natalia.
Дякую. Пане Ліме, а що б робили
Thank you.
ви?
Mr. Lim, what would you do in
Коли
this
відчули,
situation?
що
If you feel,
втрачаєте
okay, I'm
неупередженість?
losing impartiality, I'm more supportive of one side versus the other.
У вас вимкнений мікрофон. Ага.
Sorry, you were muted.
Sorry,
Oh,
I didn't
yeah,
try
fine.
to- I would put it this way, right? I think that it is only natural for all of us to go into mediation with a certain view of parties. I think the important thing is that when you are acting in your job as a neutral, you are able to divorce that personal judgment side of your brain from acting as a professional. And I think that if you are able to understand that you can do that, you would keep your views to yourself. You would understand the concept of conscious and unconscious bias. You would understand that you need to project yourself as a neutral regardless of what's going on in your brain. Because I think all of us would accept that it is impossible for you to go in there and be brain dead and be absolutely neutral and be absolutely impartial. The reality is that our brain will continue to work. We'll believe one side more than the other. We think it's fairer to, a conclusion may be reached more than one side than the other. But the important thing is that all of those thoughts should be kept strictly within, and what comes out is a facilitation that demonstrates your ability to be impartial, to be neutral, to be independent, whatever that's going on in your brain. And if you can do that, then you're a true professional. If you can't do that, then I agree with Adi, maybe that's not the case for you. You need to back away.
Дуже дякую.
Thank you
Пані
so much.
Катерино,
Kateryna,
що
what
ви
do you
робите
think?
у
What would you
випадку
do in this
відчуття
situation in
втрати
case you
неупередженості?
feel you're losing
Дякую,
impartiality?
Наталю. Насправді мене це
Thank you,
повернуло до
Nataliia.
питання
It actually brought me
можливості
back to another question, whether we can describe everything in the standards and to provide full legal certainty. And then another issue, another dimension is ethics. It is indeed a real dilemma which can sometimes happen. When talking about myself, I started taking notes, and I have at least 5 or 6 options about what I can do in this situation if I feel lack of impartiality. I can have a discussion with the parties. I had, from my experience, similar situations when in family cases I said, sorry, I needed to take a pause. I need to think about it a little bit because I'm a little bit angry about what's going on because people behave in a certain manner. They're sometimes rude to each other. So, again, I normally, to relax a little bit, I normally have a discussion about what mediation is so that they understand. And they understand they can find an agreement in a conflicting situation. So this helps me relieve a little bit. It's high time to talk about this if that may seriously affect the outcome. If this is just your internal struggle, and like our colleague said, You have to think about it, but don't express it. Don't rush to express it. Take a pause, put yourself together, reflect, breathe, and then you can come back and talk professionally to those parties. I'm not a robot, of course, I'm a human being, but I'm employed with certain professional tools. But who denies supervision or intervision? Sometimes you can invite a psychologist who can make myself a little bit more neutral and the parties too. So I myself have to be a professional and I have to take care about my own neutrality and my own internal resources. Not only during mediation, but also before and after it. Sometimes some of the issues can trigger my anger. I have experienced something similar, you know, and I can be really angry at someone. So there are more options than withdrawal. But if I understand that nothing else works and I can harm the procedure and I can kill my reputation, of course, I will withdraw as the last resort solution. It's everywhere in all the ethics codes.
Ну, та що вже після Катерини доповнювати?
Okay,
Це вже
what else can I say after Kateryna? She is so comprehensive in her answers. There is nothing much to add. But I can see Alexander Kirichenko wanted to. No, I'm the moderator here. I'm sorry. Irina, what would you do anyways?
Тоді це з якістю медіації.
And how it is in line with the mediation quality?
Якістю медіації я буду пов'язувати, напевно, рішення, які буде
I will
приймати медіатор. Тобто,
probably
якщо, наприклад, у мене виникає
focus on
ставлення
decisions
від однієї з сторін, ну,
or
воно
on
виникає ж завжди. Ну,
on
тобто,
a
коли
decision
сидять дві
from the
людини, ми
mediator.
якось ставимося
What
до
he or
кожної
she
сторони. Це
decides to
нормально,
do,
так?
withdraw
Питання,
or
як це
decide to
впливає
stay.
на
I
мою
would
здатність
actually consider it from the standpoint on my own capacity and capability to do a good job. If it doesn't affect anything, I'm going to continue to do that. But maybe I will then go to the supervisor and discuss the issue with him or her. But if I understand I cannot do it, I do not have enough resources internally to continue it, I will have to withdraw or replace a mediator by someone else. Thank you.
Тетяно, вам слово.
Tatiana, please, the floor is now yours.
Чи, можливо, якісь фінальні заключні слова
Are you happy with the answers? And let's talk about the topic of our today's discussion. I'm not happy now to be the last one because, like Irina mentioned, Kateryna said it all, you know? I have the same answer, basically. Primarily, you have to be honest with yourselves and answer yourself a question. Will you be able to be ethical enough? If you're genuine with yourself and you see the situation, you feel you have to recognize you cannot remain to be neutral. Ask yourself a question and answer honestly to yourself. So, okay, then it would be withdrawal in case you cannot do it. When speaking about a situation when one of the parties can think that you are biased and you are not neutral enough, but you feel the capacity to continue, then here the main principle will be openness. You need to disclose this information, talk about this, see how the parties respond, tell about what you think about the situation, and only then after you can make a decision. Because what may seem to be neutral for yourself may seem to be absolutely different for the parties.
Дякую, пані Тетяно.
Thank
І
you, Tatiana.
повертаючись
And now,
до неупередженості,
coming back
пані
to
Луїза, ви,
impartiality,
очевидно, маєте
Louisa,
бути неупередженою.
obviously you have to be very objective and impartial to all the participants of the forum, but please recognize this and tell us your wrap-up closing remarks about this issue. Thank you so much, Nataliia, for this great panel discussion, but I have only two hemispheres in my brain, but the panels are many, so it's so difficult to be neutral. Nevertheless, I'm so much grateful to you as a moderator and to all the speakers. You know, it is such a big pleasure from having so many like-minded people at one place. The mediation quality does not depend that much on the conciliation agreement. No. It's so good that we not only have mediators here in the virtual room, but also other professionals. Hopefully, those professionals who cooperate with mediators and those who are ready to contribute to mediation development and want to foster access to mediation, all of them need to understand mediation quality depends on so many different ingredients. I wanted to
Чи
ask
якщо ми не
whether,
встигаємо дійсно
okay,
всі ті
we
питання, які
cannot
ще
handle all the
продовжують
questions. I'm
з'являтися
sorry. We keep
чаті
receiving more and more
озвучувати,
questions in the
бачимо
chat.
руку пана
We can see
Олександра.
the
Теж
raised hand
вибачте,
from
будь ласка,
Alexander
якщо є
Kirichenko.
якісь
We do
запитання,
apologize,
напишіть їх
Alexander.
в чаті.
Please
А
type
спікери
your
так само
question
я
in the
попрошу,
chat,
якщо
and then I'm
можливо,
going to ask the
потім їх
speakers
надішлемо, і
to
ви
please
будемо
answer those whenever
вже
it is possible
посилання.
for you.
До того, як ми розійдемося, я дуже прошу,
Before we
давайте
leave,
зробимо гарне фото, як
let us take a
завжди.
nice
І
family
ще
picture as
після фото
always.
попрошу
And
затриматися
right after the
трішки, я ще
family
зробила
photo,
декілька
I'd like to
запрошень,
also
спікерів
make
в
a
тому
couple of
числі.
more announcements.
Так, давайте
And
гарне
please,
фото, будь
I want
ласка.
to ask speakers to
Спочатку,
stay with
да,
us
перед тим,
just
як
for a
натиснути
little while.
«Дозволяю себе сфотографувати», спочатку
You will see
посміхаємося і дивимося в екран.
a notification. Host wants to take your photo using group photo. So you have to allow it first.
Поки триває процес фотографування,
While the pictures are
я
being
хочу просто
taken,
зробити оголошення,
I
тому
just
що
want to
ми,
make a couple of
в тому
announcements.
числі, ми вже з'ясували, що бракує
We already
інформації,
established that there is lack of
бракує
information. There is
належної
always lack of
інформації,
proper
в тому числі на
exchanges.
такому, да,
You never have enough of
міжнародному
that,
рівні і всередині
including on at the
країни.
international
Саме
level
тому
and at domestic levels
ми
too. That is why, for this purpose,
користуємося цією
taking
платформою для
advantage
того,
of this
щоб якусь
opportunity,
інформацію озвучити.
we want to
Знаєте,
share as much information as possible.
така інформація, якою б ми хотіли
Here's some
поділитися, це
information we wanted to
інформація
share
про
with you.
платформу
This is
Mediation Help,
about the
яку ми
Mediation
створили.
Help platform that we
Ми насправді
have
створили її на
developed.
початку повномасштабного
We founded
вторгнення,
it at the
тоді,
beginning of the
коли
full-scale invasion of
так
Russia,
склалося, що величезна
Russia's
кількість
full-scale
українців
invasion of
опинилися
Ukraine.
в різних країнах.
So many Ukrainians ended up in so many
Це
different
і
countries
українці,
around the
і
world,
просто населення, і медіатори.
including our
І виникла
mediators.
потреба, що відчули, що, по-перше, є потреба більше,
We could
якоїсь
feel the need that there is
вирішенні конфліктів.
the need of resolving conflicts much more. And mediators found themselves in so many different countries without understanding what's the mediation practices in that given country and what the requirements are. They keep asking, can I practice mediation in those other countries? That's why we created this platform called Mediation Help. It is intended for mediators primarily, and also the parties of any conflicts or disputes. You can either press I'm the mediator or you're a party. You can press the respective button and you can find comprehensive information about mediation in different countries. We have Romania. We want to thank Adi for helping us filling this information. Based on your country's example, I'm going to demonstrate everything. We have Georgia, Italy, Croatia, Moldova, Serbia, Cyprus, Ireland, Greece. Many countries have joined us. I can see Kateryna was with us yesterday, and I'm not sure if she's here because she helped us fill in information on Greece. So there are so many different countries, and you can find a lot of information. It's really concise. We just send you a Google form. The structure is just the same for all the countries. There's a little bit of background information about mediation in that given country. Then afterwards, you have mediation about information about mediator requirements in that country. Then there is information about organizations that helped us fill this content. Again, you can see this ADR center from Romania. And again, whenever there are opportunities to support Ukrainian mediators, some countries provide opportunities like discounts for training, or like in Georgia, if there are Ukrainian mediators in Georgia, then the Georgian National Association is ready to give them an opportunity to run mediation sessions at the association's premises whenever needed. So I please encourage you, because there are so many international partners, we have a lot of space for more information. You can see many countries where information is not available yet. How to do it? It's very simple. You can see the partners of the platform. You can see it. You can see the partners already who have been with us and provided us with the information. And then you can become a partner. That's in the end. I'm actually encouraging associations, organizations and many other professional entities to enter their information and become our partner. This is our shared commitment for this information that we publish. We make all this information available in Ukrainian. We translate everything because the website is bilingual. I'm going to switch to the Ukrainian language website version. You can read information both in Ukrainian and English, like I said, and you can read it in English about the legal framework. Even there is a Ukrainian framework translated. You can read the law of Ukrainian mediation. We've been referring to it so many times. There are mediator requirements and mediator organizations in Ukraine, and you can find contact information if all of a sudden you decide to contact someone. There are also many other useful resources. So this is our call to Ukrainian organizations. Please join us, add your content. You can see the National Association, training centers, Family Mediators Association, and many more. Commercial mediation group as well. So there are so many different entities. Lviv Mediation Center. Like you see, there are many. So this has become a real platform for sharing information at the international level, where you can find contact information and background and more details. And there's a lot of useful stuff here. What else is available here on this platform? If you are joining us as a party, then you should press resolve the conflict. You're going to see information here. If you want to learn more about mediation, you can press the respective button and you can read about that and understand what it is and what it isn't primarily. And then after, if you know what it is all about, then you just want to find a mediator. You can press find a mediator, and there you can see this full register of mediators. This is what we referred to yesterday. We do not have a one-stop mediators register, which makes it a little bit more complicated to communicate everything outside within the domestic framework. There is no one single organization that maintains the register. That's why, with the support of the EU, we have built this platform. You can join this platform free of charge. Any mediator from Ukraine can join it if you comply with all the formal requirements of the law of Ukraine on mediation. This is a call for the Ukrainian mediators. Please join us. If you're practicing already, please come and register. And again, if you're a mediator, you just press the button, fill out the form, add information about yourself, and then you're going to see your profile. There are a lot of filters, and this is the resource where we yesterday demonstrated this links to. So you can see all the courts in Ukraine. They have links to this website. Whenever you go to their court websites, you can see those links and even a banner in the section called About Mediation. There's information that there is no single register. So according to the law, all organizations can maintain their register that have to be publicly available. But for your convenience, you can go to Mediation Help platform. So please, our international partners are encouraged to help us fill more information about your countries. Equally, you can also read about other countries, including Ukraine, and the Ukrainian partners are asked to register and fill their information. Thank you so much for giving me an opportunity to make the announcement. I want to remind you that today, after lunch, after the break, in 2.5 hours, is it 2.5 or 2 hours? I'm a bit lost. Please write to me in the chat. When are we meeting next time? We're going to have a motivation session from Bruce Edwards. This is a mediator with 35 years of experience. And also we're going to have a panel discussion dedicated to alternative dispute resolution in consumer disputes. And I want to remind you that tomorrow we're going to have 2 master classes. The first one will help you
професійно готувати, якщо є в цьому потреба, звісно.
whatever you need, of
Наші
course.
спікери демонстрували, що
Our
такої
speakers
потреби немає,
have shown that
але
there
ж
is no
не
need
у
for
всіх
it,
так буває,
but not
насправді.
everybody
Якщо у вас є
thinks
потреба
that way.
покращити свої
If you
навички
want to
створення
improve your
PowerPoint-презентації, будь
PowerPoint
ласка,
management
приєднуйтесь
skills,
завтра буде практичний
how to do PowerPoint presentations. So tomorrow there's going to be a masterclass called The Magic of PowerPoint Presentations, how to communicate effectively about mediation through this solution. There'll be a lot of practical advice on this matter. Okay, and there's going to be another neuro drawing masterclass, drawing the music of inner harmony. That's the other masterclass that we're going to have. Thank you so much. In case you have any more questions to me, then I'm going to answer them right now, and then I'm going to take a break as well. Thank you.